I'm going to call the meeting to order. Good morning, everyone. I'm going to ask Joy to roll call to verify quorum.
Thank you, Commissioner. Going to ask for Shamanda Graham.
Here.
Thank you. Joseph Gregory.
Jose Marquez in his place. Fire
And
department.
your name is?
Jose
Okay,
Marquez.
your name? I'm sorry. I'm sorry, can you repeat that?
For Jose Marquez, fire department.
Thank you.
She has a mic here.
Okay, thank you so much. Of course, Commissioner Clutter.
I'm not sure that's amplifying or if it's just recording.
Could you move a little bit closer?
Thank you.
Sure.
Okay. All right, thank you. Mr. Marquez?
I'm here.
Oh, okay, thank you so much. Commissioner Clutter.
Present.
Yes. Okay, we have Elizabeth Nauer.
Present.
Did we just lose, we just lost the room. All right, a second. Okay, so IT is on it, and they are working on getting the room back right now. I'm going to pause the recording until the room comes back, because I guess the meeting is on hold.
I think we're back.
Okay, great.
Okay, Commissioner, would you like to introduce yourself?
Yeah, so we'll do the roll call over again.
Okay. Very good. So we'll start, and I have Commissioner Clutter.
Here.
Shamanda Graham.
I'm here.
Great. Jose Marquez.
Present.
Thank you. Elizabeth Nauer.
Present.
Elizabeth Nauer.
I'm here. Can you hear me?
Thank you. Yes, we can. Thank you. And see you too. Good morning. Madeline Ligori.
Present.
Jorge Martinez.
Present.
Thank you. Russ Martinez.
Present.
Thank you. Thomas Schneckner.
Present.
Thank you. Matthew Snide.
Present. Hello.
Thank you. And welcome.
Thank you.
And I believe Matthew Smith is not here today. Douglas Swan. Okay, and Jared Whittington.
Present.
Thank you. We do have a quorum, 10 present.
Excellent. Thank you, and I'm glad we were able to accomplish this hybrid proceeding today. So nice to see some of you in person. I hope to see others of you in person soon, to be able to formally meet you in person. as we continue to recover from COVID. And hopefully we'll have a very nice positive summer with as the infection rates continue to decline, vaccination rates continue to go up. So with that, does anyone have any corrections to the minutes from the last meeting of April 15th, 2021? No, okay, so I'm going to ask for a motion to adopt the minutes as presented for the April 15th, 2021 meeting.
Motion.
Thank you. Ask Joy to call for a vote to approve the minutes as presented.
Thank you, Commissioner. At this time, I will just ask if there are any objections to the adoption of the minutes from the April 15, 2021 ECB board meeting. Okay, hearing and seeing no excuse me? Okay, hearing and seeing no objections, they are approved. Thank you,
Great,
Commissioner.
thank you so much. I want to now introduce our new ECB board member, Matthew Schneid, who was just approved with advice and consent of the city council and nominated by the mayor. I know it's been a very long process, Matthew, since I think you came to appointments almost 2 years ago with an interest in serving on this board, and I really appreciate your commitment and perseverance and your service to the city. It will be a huge value to have you as the real estate expert on the ECB board. So welcome, and I hope you get to meet all of us, or not me, but I hope you get to meet the rest of the board in person sometime soon, and we're really excited to have you.
Thanks so much. It's an honor and a privilege. Yes, hi, my name is Matthew Schneid. As Joni mentioned, this process started a long time ago before COVID interrupted this, but it's a really honor and privilege to be here with everyone. I look forward to giving my input and getting to know everyone as we proceed. So thank you so much, and I appreciate the introduction.
Great, thank you. I'm now going to ask Olga Stats to introduce both proposed rules on updating some of our language in the oath rules.
Hi, good morning, everybody. Nice to be here. Oh, good morning, everybody. Does everybody hear me? I think so. That's pretty loudly. And I wanted to present to you for your consideration adjustments and corrections to rule language. Now, as you know, we've been doing a lot of rulemaking over the last few months. And as we've been doing that rulemaking, it's required us to read the rules again and again and again. And as we've done that, we picked up errors, faulty broken cross references, and grammatical problems in the rules as we've been reading them. So one of the things that we're trying to do is, as we put together the substantive rules that you see at almost every meeting, we also wanted to pick up some of the minor errors that we've been seeing and correct those as well. And they're presented here for your consideration. And so the ones that are really of greatest importance to us are the ones that fix broken cross references. I'm going to give you just an example. For the change in proposed for subdivision C of section 229 of Title 48 changes the subdivision referenced in 1-33 from E to D3 because that has since been changed. And the rest of the changes also are in that line. So we propose that for your consideration, nothing substantive, but we think that the rules should be clear and grammatical. If anyone has any questions, I'll be happy to answer.
Hey Olga, it's really hard to hear you. Is there a microphone that you could maybe move closer?
Yeah. Oh, can you hear me better now?
No.
Is this better?
I mean, it sounds very muffled.
There's a lot of hum too.
It's gotta be the mask. So I'm going to say, it's very short and it's not substantive, so if everyone else is patient, I'm just going to repeat myself. Yeah. Do you guys mind? I'm going to take down my mask. I'm sure no one else really is going to mind. So as I noted earlier, over the course of this year, during this time, we've been putting forth a lot of substantive rules for the board's consideration. And as we've done that, we've had to read the corpus of rules again and again and again. And as we've done that, we noticed that there were some broken cross references, some grammatical problems, and some things that should just be corrected in order to make the rules as clear and as useful as possible. So during this period of time, as we go through the rules to make sure that they're up to date substantively and legally, we're also making sure that they're up to date and clear grammatically and in terms of the cross references. So what you have before you are just some of the non-substantive corrections that we thought were important to make. Of particular note are some broken cross references that we've since corrected because we've either amended rules or added rules or repealed rules that now have different numbers, so that now in the remaining sections, we want those numbers to be properly reflected. If anyone has any questions, I'm happy to answer them.
Olga, this is Shamanda Graham from DOB.
Hi, Shamanda.
Good morning. I would just like to repeat back what you said just to make sure that I did understand and hear you correctly, only because it is a bit muffled. So if I understood you correctly, these are just minor non-substantive changes to the rule based on either the incorrect numbering or incorrect grammar or something you wanted to fix like that. Did
Yes.
I understand that correct? Okay. And
That
then
is
the second question. Okay, that's good. And then the second question I have, based on my reading, it doesn't really look like any of these impact the cases that go before the Oath Hearings Division. Sorry, I should say it correctly. The DOB cases that go before the Oath Hearings Division. Is that correct? Am I seeing that correctly?
Yeah, yes, my understanding and my recollection, because we did this a while ago, as you know, this process takes very, very long. By the time they get to you, it's been before the law department for a few months and in our hands for a few months. But yes, my recollection is that there's nothing that affects DOB here.
Okay, thank you so much.
No problem. Any other questions? Thank you.
Thank you. I'm going to ask for a motion to approve the proposed rule.
Motion, Shamanda.
Motion.
Thank you. Great, thank you. I'm going to ask Joy to call for a vote.
Okay. At this time, thank you, Commissioner, at this time, I'm going to ask if there are any objections to the approval of the motion that we introduce or approve the proposed rule, updating, correcting the language in the rules as proposed. Okay. Seeing and hearing no objections, the motion passes, Commissioner. Thank you.
Great, thank you so much. I'm now going to ask Olga Stats to introduce Oath's proposed final rule regarding the authority of the Chief Administrative Law Judge to transfer cases between different divisions of Oath.
Thank you, Commissioner. This is a final, we're presenting this for your consideration. This is your final approval of a rule that we've already discussed, for which you gave previous approval. It's the authority of the Chief Administrative Law Judge to transfer cases between divisions. I'm just going to give you a short summary of this again. As you know from the last time, within Oath's rules, the Chief Administrative Law Judge always had specific authority to transfer cases from trials to hearings. So what we've done, and in actuality, the Chief Administrative Law Judge also had and exercised the authority to transfer from hearings to trials. So what we did is that we wanted to make that rule clear, and we wanted to memorialize that in the rules, and also make the rules symmetrical. And in doing that, we also cleaned up the trials division transfer rule for grammar. So what you have before you is just a transparent statement of authority that the chief administrative law judge has. And it's been through the hearings process. It received final approval from the law department, and we're putting it before you once again. If you have any questions, I'm happy to answer them.
Hi, this is Matt Schneid. Would it be accurate to say that this is essentially already happening in terms of moving the cases around, but you want to formalize it?
Yes. Any questions? Any additional questions?
Okay, thank you. I'm going to ask for a motion to approve this proposed final rule.
Motion.
Thank you, Elizabeth. I'm going to ask Joy to call the vote.
Thank you so much, Commissioner. And for this proposed final rule regarding the authority of the Chief Administrative Law Judge to transfer cases between both divisions, I want to ask if there are any objections. If you could speak or indicate if you are objecting to this rule, the approval of this rule.
Yes, Shamanda Graham, DOB, I object.
Thank you. Thank you, Samanda. I have you down. Any other objections? Thank you again. The motion passes, Commissioner.
Thank you so much. I'm now going to ask Kelly Corso to introduce the pre-sealing reports.
Good morning. Can everyone hear me?
Yes.
Yes.
Okay, great. Hi, I'm Kelly Corso. I'm the Assistant Commissioner for the Hearings Division Adjudication, and I'm presenting the cease and desist pre-sealing reports for today. We have 7 of them to the board. 6 of the reports involve backflow cases, and in all of those cases, hearing officers agreed with DEP's recommendation for no further action or sealing in those cases. The last case we have is an air case, which involves the kitchen exhaust unit. And at the hearing, the respondent's representative provided proof of work done to bring the unit into compliance with the air code. And based on that information, the hearing officer recommended that there be no sealing or further action, provided that DEP's initial reinspection of the unit and reinspections over a period of 180 days show that the respondent remained in compliance. And that's it.
Are there any questions? Okay, I'm going to ask for a motion to approve.
Motion.
Thank you, Madeline. I'm going to ask Joy to call for a vote.
Okay. Thank you, Commissioner. I will now also ask if there are any objections to the approval of the pre-sealing reports as presented by Kelly Corso. Seeing and hearing none, the motion passes and is approved. Thank you.
Great, thank you so much. I'm now going to introduce a question that was raised by Elizabeth Maurer regarding the issue of res judicata in these cases in the hearings division with respect to when and how it's applied. So I know this is something Elizabeth had raised at one of the panel meetings, and I'm going to ask her to just kick it off and then we can respond.
Thank you, Commissioner. Thanks for giving me the opportunity to bring up this issue that's sort of been nagging at me for a long time, probably since 2012 when the board first adopted the clarification of the Goldstein decision, which essentially lays out the parameters of the res judicata doctrine as has been applied by the board in various appeals since then. So I hope everybody had an opportunity to review the the materials that were circulated, the Goldstein case itself, and the clarification document. And I'll just note that I confirmed with Peter that the res judicata rule that was adopted into the board rules does not lay out the parameters of the doctrine. It's more of the procedural aspect in which it needs to be raised at the hearing, but then actually applied by the board. So the issue that I want to raise with it is specifically in the clarification document. It specifically states that the res judicata doctrine will not be applied to continuing violations, including ones that are sort of a maintenance type violation, like occupancy contrary to a certificate of occupancy. And that is not that rule was not established by Goldstein. It was not an issue in Goldstein, which was not a continuing violation, but there was a reference in the Goldstein case to the fact that it was not a continuing violation. And I just, it's something that's bothered me for a while in terms of how we've sort of had to apply it to exclude from the application of res judicata cases where a hearing officer has determined that an occupancy is legal, and thereafter another violation or another summons is issued for the same condition, and arguably at least the same facts, and res judicata cannot apply, although the respondent would naturally rely on the prior holding that the occupancy was legal to maintain. So I think it's a fairness issue for respondents that if they win and I'm saying on the merits substantively that, and with a finding that an occupancy is legal, that they should be able to maintain that in reliance that they won't later get a violation for the same thing that oath has already determined is legal. So I don't think that applying res judicata to cases like that would even require changing anything in Goldstein itself, because I think Goldstein recognized that for res judicata to apply in any case, it would have to be on the exact same facts. So if an occupancy changed from between the original hearing and the later summons, then obviously res judicata would not apply. But I think that the notion that it doesn't apply to any quote unquote continuing violations, even if the condition is exactly the same as was already adjudicated, it's unfair to respondents who are relying on a prior hearing decision that they can maintain that condition because it's been deemed legal. So it's something that's bothered me for a while, and I guess I can't remember the case that it came up in. I don't think it really affected this issue didn't affect the outcome of that appeal, but it reminded me of this issue, and I wanted to request that the board revisit it and maybe consider revising the clarification document. And I'm happy to answer any questions, but that was basically it.
Thank you. No, and I think I'd ask Peter to respond because I know he spent a lot of time researching this. I guess my question to you would just be whether this is something you all have seen happen where there might be overzealous enforcement agents who are coming back to the same property shortly, like within the same year or within 6 months. Or is it like, is it a problem where there's just too much enforcement and it's happening, just too, like, consistently? Or is it not something you're seeing?
I couldn't say that it's something that we've seen on appeal very often. We don't necessarily see Department of Buildings going out and issuing multiple violations to the same property over and over again. Cases have generally held, though, that for maintenance requirements like the ones Elizabeth mentioned, if it's a Class 1 violation, the Department of Buildings does have that right, that every day a respondent fails to maintain a premises in a code-compliant manner, engages in an occupancy contrary to a C of O, that potentially is a new violation. So that's really, I think, where the line got drawn originally back when Goldstein laid out this standard between continuing violations and non-continuing violations. It was looking to see whether or not it was a discrete act which happens once, like in Goldstein, where it was the actual installation of non-ADA compliant steps. The respondent in that case installed steps. They were being charged with installing the wrong steps. Having been dismissed, they didn't install any new steps. That one action was very discrete, and in fact, in that case, it was very specific. The IO didn't even go out on another day. The IO simply reissued a violation citing the same exact condition, same date of occurrence, without going out again, just wanted another shot at the apple. And I think in adopting the continuing versus non-continuing violation standard, the board was trying to balance factors of fairness versus safety, that what you would potentially end up having is, say this applied to just a basic maintenance requirement, that a building walls need to be maintained in a safe condition. If on a certain day a certain hearing officer dismisses a charge against a building that's 5 stories tall on the grounds that this only that the requirement to maintain a building wall only applies to buildings that are 6 stories. That's an issue which has come up in cases. The respondents claim that because of the way it's phrased, the board has said no, it applies to all buildings. All buildings need to maintain their walls. But if this hearing officer dismisses on that, and for some reason it doesn't get appealed, we would essentially be saying that because of res judicata, as long as the wall doesn't necessarily get worse, this dangerous condition that is this wall could stay until it actually falls down, potentially. So I think that...
Interject something that you
Sure.
mentioned that was very important, that you say for some reason it doesn't get appealed. And I think that's the critical issue. If the agency for whatever reason decides not to appeal it, that's on them. I mean, if the decision was wrong, it should be appealed. But I just, I think in terms of this safety issue, if it's deemed legal, and I think this often comes up in this occupancy contrary, where there's a dispute over what the legal occupancy is. If the hearing officer says, I agree with the respondent, this occupancy is legal, then for buildings to be able to come back a week, 2 weeks, 2 years later and say the exact same occupancy is no longer is not legal, but there's nothing that's changed. No facts have changed. The certificate of occupancy hasn't changed. It seems unfair to me for a respondent not to be able to rely on that. And if buildings thinks that the decision was wrong, then they should have appealed it in the first place.
I understand that, but buildings...
But what if...
I'm sorry.
This is Jorge Martinez, Department of Health. What if the decision is incorrect, but somehow the department or the agency didn't appeal it? I mean, then res judicata could be used as a shield for improper act. What happens in those cases?
I mean, in my mind, that's the agency's fault, though. That's their decision not to appeal it. So I think
it is true, but the fact remains that the decision might have been wrong.
I just feel like that makes the whole hearing process kind of worthless for the respondent. Other than getting a dismissal of that initial violation, the legal ruling is meaningless to them because they can't rely on it.
So this is Shamanda Graham from DOB. I'd like to weigh in a bit, just to provide a bit of clarity for you, Elizabeth, because I do understand your concern. So to provide a bit of clarity, when we, the DOB, write a summons for occupancy contrary, and if the hearing officer determines that the occupancy is acceptable, that does not mean that the condition that are at the location and the facts and the observations by the inspector were not in violation of other sections of our rules or laws. Even if they were, according to the hearing officer, occupying correctly. I do agree with you that if we lose a case like that and we do not appeal, that is on the issuing agency, and I do not expect the board or, the hearings division to have any sympathy for the enforcement agency that does not appeal. But at the same time, as it relates to occupancy, many times in order to allow for the occupancy, there are conditions created that may have been described in the occupancy violation, which I have to really stress is violating the person for the way they are occupying the space. That is very different from how they set up the space in order to allow for such occupancy. So let's say the hearing officer at the hearing level, they dismiss the occupancy. You know what? And I'm just making this up. This location can be occupied in this way. That does not mean that the walls, the sinks, the restrooms, the things that were put in place to allow for that, that does not mean that those things are acceptable. So I think even with the same set of facts and the same observations, if the inspector observed other areas of our rules or laws that were in violation, then I think it is correct to issue a new violation.
Well, I agree, Shamanda, but those would be different. Those would be different charges, and res judicata would not apply to the adjudication of those charges because those would be separate. So I agree with you there that So I don't.
Why Peter. But Elizabeth, that is why Peter is saying it doesn't happen. And speaking for buildings, because I am the executive director of enforcement, I can tell you that if an occupancy contrary summons is dismissed and we do not successfully appeal, we are not going to go out and write that same occupancy contrary. If we did not successfully appeal it, we would not do that. That is not part of our practice.
Well, I'm not suggesting, Shamanda, that you would intentionally do that or, would direct that on the part of inspectors, but I do think there's a possibility that.
Did we lose
But
the?
If the inspector, even a zealous inspector that went out and did such things, there are only two things that could happen. Either one, the respondent may be able to argue res judicata because
Okay, the back. Okay. I'm sorry, we lost the conference room for a second.
There are only two things that can happen in a case like that, and I understand what you're saying because you can get an inspector who maybe one is zealous or maybe two did not necessarily do the proper research, and they issue the same exact infraction that was already dismissed by the board. But in such case, there would be two things that would happen. One, the hearing officer, depending on how the hearing went, may look at the previous case, which the inspector should have done, or two, the respondent may very well raise res judicata, and depending on what the circumstances are, the board would make the decision. That's really, I believe that was why the rule was changed to make it something that the board needed to make the final decision because there's so many nooks and crannies as it relates to res judicata.
But under the board's current policy, we would not apply res judicata in an occupancy case, even if it was raised at the hearing level. We wouldn't apply it based on the parameters set forth in the clarification document.
That's correct. I just want to clarify what we had discussed. What you had mentioned earlier about what was codified in our rule. It primarily is simply that the hearing officer shall establish the record, not rule on it, but the board shall. It does contain one little bit about what the board would consider, which is the interest of justice as well as public safety. So I do think that res judicata in the enforcement context, and the rule acknowledges this, does require a bit of a different analysis than maybe res judicata in a civil litigation or something else like that. It isn't just the enforcement agency that loses, that's on the hook for losing. If you have a single family house that converts to 25 SROs into it, and for some reason it's dismissed and isn't appealed, essentially applying res judicata would be legalizing a one family house into a 25 family house without the required fire safety, without the required egress, lighting, all of those things. And it would potentially allow them to continue to occupy that despite the inherent risks that it would pose to all those occupants. Just like the wall instance I mentioned earlier, it's not really Department of Buildings that has suffered from that, but I wouldn't want to walk past a wall that isn't being maintained and which Department of Buildings cannot charge any further as not being maintained because they lost one case. And each day it's not being maintained.
Can I ask you a question? And I apologize for my first meeting, so I don't have the same benefit of the background as everyone else. But isn't at issue the same facts? So we're saying the same facts can be applied. So if there's a violation as to the 25 units in your example, wouldn't we be saying if the facts are exactly the same, then we have to apply the law as the regulation in this case, as we decided, right? So if there's different facts, it would be a different outcome potentially. Isn't that the point? That we shouldn't be litigating the same factual issues? And I imagine in this scenario, there could be many different factual scenarios.
That's my point. I think Peter's point is that there could be this extreme situation where something falls through the cracks. I think it's I mean, Shamanda, you can respond to that, but it seems highly unlikely to me that Buildings would not appeal that case.
I'll tell you one thing. You know, I'm over here fighting at the bit, Elizabeth. Buildings had better appeal a case like that, so I wouldn't really worry about something like that. And I think what I need to make very clear, like the way the inspectors write the summonses, right? So if there's occupancy contrary, the inspector is going to write all of the facts that makes them believe that the occupancy is contrary. But those facts would include other things that they observe that are actually violations of other sections of our rules, of our laws. So what happens is you have this big summons that tells you this person's occupying this space incorrectly. They don't have sprinklers. They don't have this, or they have 25 rooms where it should be a one-family apartment. And the inspector has given all those facts when, in actuality, the only fact that they had to give was the current occupancy or what is legally acceptable versus what they saw, which would have been the 25 rooms. Our inspectors are going further to state the other things that they saw, and when they do that, that is because they're writing that one summons opposed to writing the 10 or 15 or however many could be written. I mean, in these cases, I'm going to tell you now, it is really simple. Once you have that occupancy contrary, depending on the type of scenario you have, like Peter said, you get, especially if it's like an Airbnb situation, depends on the situation, you get sprinkler requirements coming into play, egress requirements coming into play, ventilation requirements coming into play. There's all of these different requirements that then kick in. And the inspector may very well only write occupancy sometimes, not all the time, but when they do, if that were dismissed, then we're saying, oh my gosh, we have this 25-room, one-family house. People can really, really get hurt in situations like that. So the department would, one, appeal, and then two, if we did not prevail or for whatever reason lost the appeal, we would try to ramp up our enforcement in other ways, keeping in mind that the major goal is compliance and to get that location to a safe space. Because in these instances, this is where people lose their lives in emergencies, fires, and things of that sort.
I'll just say that I think that the concerns that Peter are raising are like that the hearing officers are going to get it wrong, and that Buildings is going to get it wrong by not appealing, and or that the board is going to get it wrong on the appeal. So I think those concerns are, I mean, I would just say that we shouldn't be making policy based on concerns that like a multiple chain of events will go wrong in that fashion at oath. You know, sort of to the detriment of respondents who are, you know, who might be trying to just comply with the law and maintain their building in what they think is a legal manner. I think in many cases, they're likely where there's a dismissal because buildings, for example, just didn't produce enough evidence of the legal occupancy. That also, if they came forward with more evidence of legal occupancy on a subsequent summons, then again, res judicata wouldn't apply in that case because the ruling was not based on the same evidence.
I don't think that's the way that the board has applied res judicata as far as not having sufficient evidence. If it was simply, we can go back to the stairs case. If it was dismissed because DOB didn't come forward with sufficient evidence that these stairs weren't ADA compliant, and then they reissued that, the board would say that is res judicata. DOB had its chance to submit the evidence, they didn't. But I think part of what the distinction that is a fine distinction between res judicata and collateral estoppel, and really the Goldstein case speaks to claim preclusion, not issue preclusion, and I don't think the board has been very stringent on issue preclusion, and a lot of the reasons why a occupancy contrary charge would be dismissed would be based on particular issues. Like you're saying, DOB failed to the issue of what is the legal occupancy of this building, or the issue of how many rooms were actually being occupied on a particular day. Those are things that the board hasn't applied, and those are the reasons why you would generally say, okay, you can't issue another occupancy contrary charge on Tuesday if it was dismissed Monday, because you haven't shown that the issue of how many rooms were being occupied has changed, or you haven't shown that the legal occupancy of this premises has changed. So that's the distinction to some degree of what continuing violations versus non-continuing violations also hinges on, is collateral estoppel versus res judicata.
I mean, I think that's splitting hairs to a certain extent. Collateral estoppel is a part of the doctrine of res judicata, and I guess I'm just raising this issue as sort of from a policy perspective of allowing people to rely on decisions of the board, and whether we do that. So versus.
Is there a proposed change to the document that's on the table?
I just was up at a panel meeting and was invited to present on it. But I could propose modifications to the clarification document if there was interest in that.
It might be appropriate to do that when a case comes up. Then the case itself can go to the full board. A decision could be issued after debate by the full board, and then the document could be modified based on how that decision comes out.
I mean, I'm not on every panel, so I may not.
Well, we could, if there is a claim on a continuing violation where res judicata is raised, we will ask that the panel brings it to the full board.
Oh,
sorry, can I? This is Tom, as a member. I'd be in favor of us coming up with something, laying exactly what are on this. This debate is very interesting. Remember, he was the substantive member worked on in 2012. I remember Julian Balsam cornering me back in the day. I think waiting for a case to come up might be too little, too late. I don't mean it like we can't get it right, but I think this is a very worthy debate. I take it at face value, Shamanda's diligence and willingness to, hunt down any violation, that isn't fully fleshed out, or her thoroughness is not up for here. What I'm concerned is that if we do have an ongoing violation, I mean, a lot of our cases, you know, we just kind of, we write them and then we expect compliance and we don't have any kind of equitable means by which we can, you know, cram down change. What we do have is the ability to write new summonses. So I do think that coming up with something, you know, we can take a couple meetings if we have to do it, but I would be more than happy to team up with Elizabeth and whomever from the agencies to flesh this out. You know, I live in a crumbling building, and I do take very seriously the need to be vigilant for ongoing violations, and where something like a stop work order isn't observed, that's very cut and dried. But where we have a dangerous condition that isn't abated promptly, we do need the ability to take action, punitive or otherwise. So I think, Peter, you're right that we could probably hold on until one of these becomes ripe. But I'd rather get the information, you know, the respective views of everybody, you know, memorialized into something we think is appropriate. That's just my reaction to the debate, which I think is, you know, important and lively, and I wish we did more of this, frankly.
All right, I think Olga wanted to say something.
Yeah, right. Hi, everybody. I just wanted to point something out. It would be very difficult. I think if you want to.
Sorry, Olga, can you get closer to a microphone? You're very hard to hear.
Yes, I am. I'm as close to a microphone as I can get.
That's better. That's better.
You're better now. Whatever you.
Okay.
Yeah.
So what I wanted to say basically is we have to keep in mind that there are police powers that we have to keep in mind here. Oath, of course, is the tribunal, but the enforcement agencies have police powers that we really cannot legislate beforehand or decide on beforehand. And I think that the reason that there's so much room in the res judicata rule as it exists is to allow the appeals panel to do things on a case-by-case basis, which I think is critical in this area. I don't think that this section is really amenable to having a policy that is set in stone. There are too many factors when we listen to Shimona speaking or Peter or when we just read the cases. Too many things come up in individual cases for us to have some sort of a policy that will apply in every single case. I think perhaps we can look at it and say perhaps not do an absolute refusal to do a continuing violation, but it's absolutely critical that we give the agency the flexibility on a case-by-case basis to do this. I don't think it would be this is not really amenable to a hard and fast rule, because I don't know the extent to which oath has authority to interfere with the police powers of like the fire department or the buildings department if they decide that they have to go back in a particular place within a particular number of days. So I think that those are things that have to be kept in mind as we try to reach some sort of consensus here. I think a consensus can be reached, but we have to be very careful about what it's going to look like and whether we're going to do something set in stone. Thank you.
Olga, just to respond to that, if I may, I was not proposing that the rule be changed, which, as Peter mentioned, references public interest and safety or whatever. I was proposing revisiting our internal clarification document, which now reads that that res judicata will never apply to a continuing violation and has been sort of interpreted as kind of set in stone, I think, through the appeals decisions. So I was just proposing maybe making it more flexible, but not proposing to put further restraints on the board or change the actual rule.
Yeah, no, thank you so much for raising it. I think it's definitely something we should think about and talk about more. Again, from my perspective, I'm a little hesitant to consider any kind of clarification change or rule change without knowing how often this actually happens, because I haven't seen evidence of, again, like overzealous, over aggressive enforcement where someone is inspecting and then 6 months later it's the same condition, as opposed to maybe 4 or 5 years later going back to the same unit. Now, you're all seeing more cases than I am, but I would be interested in seeing evidence of that kind of overzealous enforcement that would require some type of clarification change. Is there anyone else that wanted to speak on this issue, or can we move on?
Just quickly, this is FDNY. As the first responders, I would just remind everyone that's put this forth to remember that this deals with the health and safety standards, which are changing constantly. So we wouldn't be in favor of putting a legal straitjacket on oath, rather allowing oath, as they have been doing, to decide on a case-by-case basis what they deem appropriate and when res judicata should apply. Remember, this has a definite finality to it, and I believe that in order to protect life and property, the agency should not be prevented from relitigating these issues, and for oath to then consider it in the light of what is best for the public. Remember, the one side of it is, well, this is a burden for the respondent. However, the other side of it is that lives are in danger, and what's best for the public at large. And as first responders, we're very concerned with that, because if Department of Buildings loses a case like this, and let's face it, there is no system that's perfect. With all respect to Department of Buildings and their ability, and I know they're very competent, but no system is perfect. And if something does fall through the cracks, we're the ones responding to the building, and we're the ones that are trying to save the lives that are in there. So please take this into account when deciding. It's not just one-sided, well, you know, it's not fair to the respondents. It's also what's in the best interest of the public at large.
Okay, thank you. I think we're going to move on unless someone wants to make a final comment.
I'll just make one that having heard all of those concerns, I would say if we were going to revisit the clarification, certainly the egregious case or the dangerous case could be taken into account, that there would be a caveat on the application of res judicata where there was a real danger to the public or occupants, etc.
Okay, great. Thank you again, Elizabeth, for bringing this to us. I'm now going to ask for a motion to go into executive session to discuss new decisions in the cases listed in the judicial report.
Motion.
Thank you.
Okay, so if everybody who is not employed or interning with Oath or part of the board either wants to disconnect, if you don't want to disconnect, I can put you into a waiting room and bring you back in when the executive session is over. I don't think there's much to discuss after that, but I can do that. There's a lot of new names because of the interns, so Tim, do you recognize all the intern names and can tell me if anybody is on who is not an intern?
The LA Planter, that doesn't, I'm not sure who that is, but the other name.
Right, okay.
So seem familiar.
Yeah. One second. Okay, I'm going to pause the recording now.
Thank you, Commissioner.
Okay. Are there any additional questions? We're now back in public session. Okay, and as you all know, additional future panel meetings are divided into AM and PM sessions. with different board members for lighter packages of draft decisions. The next board meeting will be August 12th, 2021. And I'm going to ask for a motion to adjourn the meeting.
Motion.
Great. Meeting adjourned. Thank you all so much.
Thank you. Bye, everybody.
Bye.
Thank you. Bye,
Thank you.
everybody.
Bye.